A $1.2 billion company sent me a letter demanding $1,847. 90 days later, I was holding a check for $34,000. And the best part is, I didn't need a lawyer. I didn't need money. I didn't need any connections at all. I needed a pen, a form, and 3 nights reading a document they themselves forced me to sign. This is the story of how Marcus Reed, a freelance IT technician from Sacramento, used the rules of a billion-dollar corporation against itself inside the very system it created. And if you stay until the end of this video, you will understand exactly how he did it step by step. Because if you ever receive a letter like this, you will know precisely what to do. Stay with me, because this does not end the way anyone expected. Marcus Reed was a freelance IT technician, 34 years old, living in Sacramento, California. The name has been changed for this video. He was not rich, he was not poor, the kind of person who paid his bills on time, kept his receipts, and had absolutely never set foot inside a courtroom in his life. In March of 2022, Marcus subscribed to a corporate software service. I will call it TechFlow Systems, a mid-sized company valued at $1.2 billion. The product was a project management platform for freelancers. The plan Marcus signed up for cost $89 a month. Everything went fine for 2 months. In the 3rd month, Marcus noticed the platform had charged him $89 twice in the same billing cycle. He opened a support ticket, got an automated response, opened another one, got another automated response, waited 3 weeks. Nothing. Marcus then tried to cancel his subscription, and that is when, at this exact moment, the real problem began. The cancel button simply did not work. Marcus clicked. Nothing happened. He clicked again. A message appeared saying his request was being processed and to please allow up to 72 hours. 72 hours later, nothing. The month turned over. Another $89 charge, and another duplicate on top of it. Over 6 weeks, Marcus had tried to cancel his subscription 9 times, had sent 18 emails to support, had made 3 phone calls that went to a hold queue and were never answered, and had been charged 4 times beyond what he expected, totaling over $350 in unauthorized charges. Marcus did what most people would do. He disputed the charges with his credit card company. 2 months later, the certified letter arrived. TechFlow Systems did not recognize the disputes. They claimed Marcus had violated the terms of service by disputing legitimate charges, and they were demanding $1,847 with the disputed amounts plus interest, administrative fees, and an unfounded dispute fee of $350. Marcus did not have $1,847 to spare, and even if he did, he was not going to pay, because he knew in his gut that he did not owe that money. The problem was, how does a freelance IT technician prove that against a $1.2 billion company? Well, he went to do some research. Marcus could not afford a lawyer. An initial consultation in Sacramento ran between $300 and $500 an hour. But Marcus had something most people underestimate, which is time patience and an analytical mind sharpened by years of debugging code. On the first night, he reread word for word TechFlow's terms of service, 23 pages of dense legal text. And on page 16, he stopped. Section 11.4, Clause B, 3rd paragraph, 18 lines that TechFlow clearly expected nobody would ever read. The clause stated that the company commits to providing a written response to any formal cancellation notice within 5 business days. Marcus went back through his records. He had sent formal cancellation notices by email on 9 separate occasions. TechFlow had never responded to any of them in writing. Every response had been automated with a ticket number and a receipt confirmation. Never a direct human reply. According to TechFlow's own terms of service, the very document they had forced Marcus to agree to the company had violated the contract. Not once, 9 times. On the second night, Marcus went deeper. He found the California Consumer Protection Act of 2022, which requires that any digital subscription service provide a cancellation mechanism as simple as the sign-up process. Marcus had signed up in under 2 minutes. He had been trying to cancel for 6 weeks without success. That was not just frustrating, it was illegal in the state of California. On the 3rd night, Marcus found the Federal Trade Commission Act Section 5, which prohibits unfair or deceptive practices in commerce. And more importantly, he discovered that the California Small Claims Court allows claims of up to $12,500 with no attorney required and a filing fee of just $75. But before going to court, he did something that shows a level of strategic thinking most people would never apply to a situation like this. He built what I am going to call the package. The package was a 36-page dossier that Marcus spent an entire week building. He organized everything in chronological order with precise timestamps, screenshots of every cancellation attempt, printed copies of every email, sent bank statements with every duplicate charge highlighted, and a visual timeline showing exactly when each violation had occurred. More important than anything, Marcus drafted a formal 3-page letter addressed directly to TechFlow Systems' legal department. The letter was not angry. It was not emotional. It was surgical. The letter cited by section and paragraph number each of the 9 contract violations. It cited the California Consumer Protection Act by its exact section number. It cited the FTC Act, and it ended with a specific proposal where Marcus would accept a full refund of the $356 in unauthorized charges plus $500 in compensation for time and damages, totaling $856. If the company did not respond within 15 days, Marcus would file in small claims court for the maximum allowed amount of $12,500. Marcus sent the letter by email by certified mail with delivery confirmation and uploaded a copy to TechFlow's own ticket system, creating an irrefutable record that the company had been formally notified. Then he waited. On the 12th day, 3 days before the deadline, a response arrived. Not from customer support, from the legal department. The company offered to refund the $356 in duplicate charges without admitting fault without the $500 in compensation and required Marcus to sign a full release agreement before receiving any payment. Marcus read the release agreement carefully. The most important clause was buried in paragraph 6, whereby accepting the refund, Marcus would waive any present or future legal action against TechFlow related to this or any other matter. In other words, the company wanted Marcus to surrender all of his legal rights for $356. Marcus replied with 2 words, declined, respectfully, and the next morning at 9 a.m., he went to the courthouse. The Sacramento Small Claims Court is in the middle of the city. Marcus arrived with the package, 3 printed copies of every document, and a numbered list of every point he intended to raise. He had practiced his argument out loud, timed it over 4 consecutive days. Form SC-100, which is the small claims initial filing cost, $75 to submit. Marcus listed his damages as $356 in unauthorized charges, $500 in damages for violations of the California Consumer Protection Act, and $500 for contract violations under TechFlow's own terms of service, totaling $1,356 requested. The hearing was scheduled for 42 days later. TechFlow was officially served. 28 days after filing 14 days before the hearing, Marcus received a call from a number he did not recognize. It was an attorney, not from TechFlow's customer support, from the external law firm the company had specifically hired to handle Marcus's case. Think about that for a second. A $1.2 billion company had hired an outside law firm to defend a $1,356 small claims case. That made no economic sense unless the company had far more to lose than $1,356. The attorney was polite and professional. He asked what a reasonable number would be to resolve the matter before the hearing. Marcus knew that call was a probe because the company was trying to find his floor before revealing their ceiling. He replied that the amount was in the filing and that he was available to discuss in writing through a formal offer. The offer arrived 2 days later with $3,200, full reimbursement plus compensation, no admission of fault, and with a confidentiality agreement. Marcus counter-offered $8,500 with no confidentiality agreement because he wanted to be able to tell the story. Silence for 4 days. Then the final offer arrived. TechFlow Systems' final offer was $34,000. $34,000 to close the case before the hearing. Why such a high number? Marcus found out afterward through a search of the California court's database that TechFlow had been notified in at least 4 other similar cases in the preceding months, all involving cancellation problems. A well-documented case like Marcus's, if it went to hearing and resulted in a public decision, could be used as precedent in larger actions, including potential class action lawsuits. The company was not paying $34,000 for Marcus's case. It was paying $34,000 to make sure Marcus's case never became the first brick in a much more expensive wall. Marcus accepted, with one condition: no confidentiality clause. He had the right to say he had received a settlement without disclosing the specific terms but confirming the outcome. TechFlow's attorney hesitated, consulted, and agreed. The agreement was signed on a Monday morning. The following week, Marcus used part of the $34,000 to subscribe to a project management software from a smaller TechFlow competitor, at a fair price, with a cancel button that worked. Marcus Reed's case was not luck, it was method. And the method is repeatable. Here are the 4 things anyone can do in the same situation. First thing, document everything from the very first problem. Every email, every contact attempt, every bank statement. Precise timestamps, screenshots with the date visible. Documentation is your legal foundation, and without it, you have no case. Second thing, read the terms of service before going the legal route. Companies frequently make the same mistakes they impose on their customers. Clauses that create obligations for the company, and not just for you, are pure gold in situations like this. Third thing, know your state's law. California has the Consumer Protection Act. Texas has the DTPA. New York has General Business Law Section 349. Many of these laws include multiple damages clauses, which means you may recover 2 or 3 times your actual loss if you can prove unfair practices. Fourth thing, and this is the most counterintuitive one, do not accept the first offer. Companies make low opening offers because most people accept them. If you have made it far enough to file a formal, well-documented claim, the company already knows you are serious. The first number they give you is almost never the last. The power is not in having money for a lawyer. The power is in knowing more about the contract than the company expected you to know. Marcus Reed was not a lawyer. He was not an activist. He was a frustrated IT technician who received an unfair letter and decided instead of paying or giving up to do something different. He read, "That is the core of every story we tell on this channel. It is not about luck or connections or economic power. It is about understanding the system well enough to use its own rules strategically. The system was built with layers of complexity, precisely so that most people would not bother to understand it. But for those who do bother, the loopholes are there. If you are going through a similar situation with unauthorized charges, blocked cancellations, or violated contracts, this video is not legal advice, but it is a map. And sometimes a map is all you need to get started. If this story was useful to you, subscribe, because there is much more where this came from. Next week, the story of a tenant in Chicago who found an obscure clause in her lease that forced her landlord to pay back 3 months of rent, with interest. Until then, read your contracts, read your state's laws, and never assume the company read those documents more carefully than you can.